Hi, my name is Jamal Jackson, and I am the CEO and Managing Attorney of Jackson Corporate Law Offices. Today we're going to be discussing businesses and some of the legal pitfalls that they can run into when using social media. So, what we're going to talk about today is one, we're going to understand what constitutes social media. Then we're going to talk about the general dangers that are applicable to businesses' use of social media. And then we're going to learn some tips on how to protect your business. So, first off, what is social media? So the Merriam-Webster dictionary definition of it is forms of electronic communication through which users create online communities to share information, ideas, personal messages, and other content, such as videos. So here are some examples, and we don't really need to go into these because I'm pretty sure everyone watching this video has some basic level of understanding of what social media is. Some of the main ones: Facebook, Twitter, LinkedIn. So these are the examples of social media. And this shows some of the reasons why businesses use social media. It is one of the cheapest and easiest ways to cast a wide net through advertising in order to get some of your consumers to become familiar with your brand, familiar with your product, to make certain offerings for your services or goods. So this just shows that pretty much almost every consumer is on social media, and social media serves as a great marketing tool as well as a brand or a strategy for branding your business and creating widespread awareness and brand recognition. So these are the three concerns that we're going to talk about today: intellectual property infringement. So we're going to be talking about copyrights mostly, but copyrights and trademarks; false advertising and endorsements. So what happens, or how do you properly advertise your business across social media? And then what happens when you have endorsements that are put out there? So for instance, when somebody endorses you on Yelp. And then right of publicity. So when is it okay to use someone else's images, name, and likeness in connection with your goods or services? So first off, we're going to talk about copyright infringement. Now, copyright is a protection of work authorship, such as writings, music, and works that have been tangibly fixed to a certain medium. So these are images, these are music compositions, these are videos that have all been pushed out on a social platform or just on a public platform. So how do you know what content you post is copyrighted, and then how do you know when someone else's content is copyrighted? Very, very simple. In 1886, stated that once an idea is fixed to a tangible form, and released to the public, it automatically receives copyright protection. So there's nothing more that anyone needs to do but to create a video and then put it into the public space, or to create music and then put it online, or in some way, shape, or form fix it to a tangible medium and put it into the public marketplace. At that point, it automatically receives copyright protection. So the sites that are most susceptible to copyright infringement: YouTube, Facebook, Pinterest, Instagram. So these are platforms where you can post pictures, where you can post videos. And so an example of copyright infringement, and that is the unlawful use of someone else's protected work, is the oneselltheday.com. And this is the Harlem Shake video. A lot of people remember this back in 2013. It was a dance craze that went viral. And so at oneselltheday.com, there was an employee that posted a video during the Harlem Shake. And at that time, the song was #1 on the billboards, and the recording artist sued YouTube, and YouTube started taking the videos down. So everybody was putting up Harlem Shake videos, and when it came to companies putting up Harlem Shake videos at the workplace or in connection with their goods or services, YouTube started taking them down because it was an infringement on the copyright of that Harlem Shake song and of that Harlem Shake, of the original video. So this is a question that I get asked all the time: does giving credit to the original owner protect you from infringement? No, not at all. The owner has the exclusive rights of reproduction. So that means that unless you have the consent of the original owner, there is no way to get around. Well, not that there is no way, but unless you have the consent, it is copyright infringement. But there is an out. And this is called fair use, the fair use doctrine. These are exemptions from copyright infringement. So fair use involves things such as criticism, comment, news reporting, teaching, scholarship, and research. And these are often used, such as teaching. A lot of times there are teachers that in the course of their academic programs, they utilize copyrighted material in order to push a point across to some of their students. These are let's say that there was a video on human evolution that was copyrighted, and there was a history teacher that wanted to utilize that, or a sociology teacher that wanted to utilize that in class. If it was not done for commercial purposes and done for a teaching purpose, then it would fall under fair use. So this is how you assess fair use. This is the criteria. So the purpose and character of the use, including whether or not it's used for commercial purposes. So are you charging people for it? Or is it for a nonprofit or educational purpose? The nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyright as a whole. So if there's a 15-minute video and you use a 5-minute clip of that video, is that copyright infringement, as opposed to using a 5-second clip of that video? And then the effect of the use upon the potential market for or value of the copyrighted work. So if I'm putting this out into the public, does it diminish the value of the original copyrighted work? Now, these are taken into what's called the totality of circumstances. There's no one set way to assess whether or not you are involved in copyright infringement. You use all of these factors, and you talk to an attorney, you talk to someone who's knowledgeable about the space, and they can give you an opinion. Now, another issue is user-generated content. Now, some of you who are watching are business owners who have websites, and you allow third parties to post content on your website. Now, could your company be liable for the content that's posted by a third party? Yes. So if you have spaces where people can post content and somebody posts something that's copyrighted material, or they post something that's trademarked and they use it in the wrong way, your business could be liable for the damages unless your website's terms of use are in order. And so terms of use, those are policies on your website that pretty much set guidelines for individuals using your website or using your social media platform. Now, the Digital Millennium Copyright Act states that you can limit your liability for third-party generated content if you have DMCA takedown policies, which you can find those online, or you can talk to an attorney. If you have no actual knowledge of the infringement and you do not benefit from the infringement, and then you quickly act to remove the infringing content. So these are all the things that you have to do in order to limit your liability from third-party user-generated content that infringes on somebody else's intellectual property. Now, false advertising. I'm pretty sure that if you're a business owner and you're watching this, you have advertised your business on social media, whether it's Facebook, Twitter, or any of the other social media platforms. Now, the Federal Trade Commission, or the FTC, has specific guidelines for keeping people, honest about their advertising, their advertising practices online. So, in general, the FTC states that you cannot misrepresent where you meaning your business, where you come from, what you do, or how you do it. So you can't lie about where your business is from, about what your business does, or about how your business does it. And then you can't lie about your accolades or licenses. You can't use falsities to get ahead of your competition. So in other words, they're saying that you have to be extremely honest when you're advertising across any social media platform. Now, with misrepresentation and lying, there also comes the half-truth. So you have to give clear, honest statements that reveal the whole truth. And Spirit Airlines learned this the hard way. So in 2011, the Department of Transportation sued Spirit Airlines because they advertised cheap airfare on Twitter, but they didn't express the conditions to receiving promotional rates. Now, of course, on Twitter, you only have 150 words or 150 characters, sorry. So you can't write out a long message. This is of no consequence. You have to make sure that you are not telling a half-truth. So if you can't tell the whole truth on Twitter, you have to find another avenue for expressing your advertisement. Spirit Airlines paid a $50,000 fine, and There are other businesses who have been caught in the same situation where they've only told a part of the truth in advertising their goods or services, or a promotion for their goods and services, and they've gotten in trouble for it by the FTC. False endorsements. Now, the Federal Trade Commission also regulates endorsements. So they say that endorsements must reflect the honest opinions or experiences, clearly disclose generally expected experience, clearly disclose if the expected experience is different from what that person who is presenting that experience receives. So that's saying that if that person received a much better than average experience, then that has to be disclosed. So a lot of times in commercials you hear that user experiences may vary, and that's all to say that this may be an atypical experience, or this may not be the norm, but this is what happened for this one particular person. And then you must disclose any material connection. So if you have an employee that goes on and writes a review, or if you're giving anybody a reward or an award for writing a review for your company, you have to make that known. You have to clearly state that there is some material connection between the person giving the endorsement and your company. Now, right to publicity. This is another thing. This is another area that gets people in trouble. So the right of publicity is someone's control over their image, likeness, or name. And so in Illinois, for instance, the state statute states that you may not use a person's likeness in connection with the sale or offering of goods or services without their prior written consent. So that means if you're going to connect somebody to your good or service, you have to have their consent. They have to say okay for you to be able to do that. So this is applicable during a person's lifetime plus 50 years after their death. So this usually comes about with celebrities and other well-known people, even if they're not worldwide known celebrities, if they're locally famous, or if there's a particular purpose for a community to really know this individual, that's where it usually comes up. So you have to understand that a person's image and likeness is very sacred, and there must be consent, and there are only certain ways in which you can use it. So, for instance, you can't tweet and hashtag somebody's name unless they give consent. So you can't say be a champion like hashtag Michael Jordan and use our products. That's an infringement on his right to publicity. And then this also occurs with reusing pre-existing endorsements. So let's say that you have a website up and someone grants you permission to use an endorsement on your website for your products or services. If you build a new website, or if you want to create any other marketing or promotional material, you have to get that person's consent to utilize that endorsement on that other medium. So in order to transition that endorsement to a new website, or in order to put that that testimonial in a different video, or on a different marketing platform, you have to get that person's consent again. So this Facebook learned this one the hard way. So in 2011, Facebook had what was called sponsored stories. Now, Facebook, whenever a user would click like on something, Facebook would create an ad, and they would target that person's network. So that people in that person's network would see their friend's face, and they would see an advertisement for the product or good that they liked, and so there were a group of plaintiffs that came together and engaged in a class action suit and sued Facebook. And basically what they said was that they drafted millions of Facebook members as unpaid and unknowing spokespeople for various products, and that they violated these individuals' rights of publicity. Facebook paid out $20 million to settle this incident. So all in all, you have to know how to protect your business. You have to know that using social media can be positive, but it can also open you up to liability. So one, beware of posting copyrighted material on your website. If you're going to, or on any social media platform, if you're going to post copyrighted material, make sure that it falls under the fair use doctrine. Implement a terms of use policy for your website. Now, if you have a website and you don't have a terms of use policy, you are really leaving yourself open to liability. So that is something that you need to set as a high priority in your operations. Get that done. You can also implement a social media use policy for your employees. So if you have employees and you want to make sure that your employees are following these rules as well, you can put those into a policy statement. Don't advertise half-truths. Don't misrepresent yourself. Fully disclose endorsement connections when applicable. So if you're giving rewards, if you have an employee go on, if there's any material connection between the person that's making the endorsement in your company, you have to fully disclose that. Then always get consent before using a person's likeness in advertising, and always get consent before reusing a customer's pre-existing endorsement of your brand. So this is just a small checklist of ways that you can protect your business if you're utilizing social media as a method of branding your company, as a method of marketing your products or services, or as a method of client or consumer engagement. Now, again, my name is Jamal Jackson, and I hope that you learned something about social media use and how to protect yourself during this session. If you have any questions, all of my contact information is located on this page. Please feel free to reach out and give me a call or shoot me an email. If you would like this PowerPoint presentation, also send me an email. I invite you to also check out our website at jacksoncounsel.com. We have other content on there that you can go and look around and see if there's anything that can help you in the operations of your business. I thank you for watching. I thank you for joining me today, and I look forward to providing you with more content in the near future. Thank you.